Your Honour, before I begin my oral submissions for this 590AA application, I wish to tender my written submissions. Your Honour, if it pleases the Court, I wish to relay the facts leading up to and subsequent to my client's arrest. I've been instructed that the police were made aware of a break-in at 17 Pickford Street and found my client at the property. One of the arresting police officers asked my client for his name and how old he was. My client responded with the answers Johnny Wishbone and 14. At this very early stage, the arresting officers knew my client was an Indigenous minor. However, no steps were taken towards contacting his parents or his guardians. My client was then put in the back of a police car with a plainclothes officer and driven around the neighbourhood where a number of break-ins had been recorded. Each house they drove past, the officer in the back seat with my client questioned, or rather told my client, that these places were broken into, and did my client do the break-in? My client's responses were words to the effect of, "Yeah, probably, I don't know, and I think so." Again, during this process, no attempts were made to contact my client's parents or guardians, even though the officers knew that my client was a juvenile. I'd been given instructions that my client was then taken to the local police station, where my client was put in a room with a woman known to him as a support worker named Donna. Donna was afforded a few minutes with my client, during which time she told him to just answer the questions and tell the truth. The police officer then returned to the room, where there was an interview of record with my client making full admissions to the 106 charges against him. Your Honour, I make submissions that the arresting police officers breached both the Police Powers and Responsibilities Act and the Police Powers and Responsibilities Regulations in relation in their interviews of my client, and that the record of interview and any statements made arising from the conduct from that day be inadmissible evidence. As I mentioned before, the police were aware from their very first contact with my client that he was an Indigenous underage child. Section 421 of the Act I mentioned before, which has been included in my written submissions, applies where a police officer wants to question a relevant person and they reasonably suspect that that person is a child. Your Honour, as I have repeatedly mentioned, my client informed the police officer on their first encounter that he was merely 14 years old. There can be no other inference from this correspondence than the police officer knew that my client was a child. Further, Section 421, subsection 2 of the Act requires that the officer must not question the child unless, before any questioning has started, the officer has allowed the child to speak to a support officer chosen by the child in the circumstances where the conversation will not be overheard. Your Honour, I firstly make the submission that my client was not given the opportunity to access a support officer at a stage practicable to the situation, and secondly, that the support officer that was eventually handed over to him was not chosen by my client. This could have drastically affected how my client made his admissions. If, for example, my client's parents were contacted and had been present, they may have told my client not to speak to the police officers at all in the interview, which would have resulted in my client not making full admissions to the charges against him in this court. Your Honour, Section 5 of the Police Powers and Responsibilities Act, which is also included in my written submissions, provides that some of the purposes of the Police Powers and Responsibilities Act are to provide powers necessary for effective modern policing and law enforcement, to provide consistency in the nature and extent of the powers and responsibilities of police officers and to ensure fairness, and to protect the rights of persons against whom police officers exercise powers under this Act. Your Honour, the police officers involved in the arrest and interview of my client are plainly in breach of the Act and have also contravened the rights of my client. As members of law enforcement should well know, the law is made to be complied with, and not just the parts of the law that are convenient to them at the time, but the whole law. It is simply unacceptable that the officers conducted themselves in such a way, ignoring Section 421 of the Police Powers and Responsibilities Act, and consequently submitting what counsel believes to be inadmissible evidence. To recap, Your Honour, the police officers who arrested and interviewed my client knew that he was an Indigenous minor. That is not in question. At no point during the arrest or the interview did they make any attempts to contact his parents, his guardians, or a support person of his choice. As the record of interview appears to be the only evidence that the Crown has against my client, I make the submission that there is no admissible evidence to proceed with prosecuting my client for the 106 charges presented against him in this court. Your Honour, that concludes my opening submissions.